Bom dia a todas e a todos. Good morning, everybody. It's a great honor for us here at IASP to receive Dr. John Fritz Scatton and our friend Otto Lobo from CVM. And I will ask Marina to introduce both of them and make the introduction of the speech. Thank you. Okay.
Hello, hello. It's on? It's on. Hello. Hello, everyone. Good morning, everyone. It's a great pleasure to welcome you all to this seminar, and which is also being streamed on live on YouTube. So I'm here to introduce our guest. John Fritz Scanlon. He's a former DOJ Assistant Chief and Trial Attorney, U.S. Department of Justice, of counsel at Queen Emanuel Urquhart and Sullivan LLP. I don't know if I pronounced it correctly. And we have here our dear Otto Lobo. He's a commissioner at the Brazilian Securities and Exchange Commission, our CVM, and also, of course, our chair of our banking committee, Flávio Maia. He's an attorney and a member. He's been a chair. He's deputy chair of the Banking Law Committee. The chair is Alexandre Pacheco, who unfortunately was not able to be here today. Now, we have also Eileen Patricia Najarian. She's a counsel. She's not here, but she will be supporting us. She's a counsel at AGU, the Brazilian federal government, and a member of our Banking Law Committee here at the São Paulo Lawyers Institute. So let me begin by extending our warm welcome to our distinguished guest. And we are especially looking forward to hearing your impressions and what you have to contribute. That might be a lot you have to bring to us today. So without further delay, let's begin, and I will hand the floor to you.
Okay. So thank you so much for this very kind invitation, which was not an invitation. Basically, we
came
together. Okay, so thank you so much, Flávio Maia, for this kind invitation to be here today. I know Elaine is coming here later, and thank you so much for putting together this program that was put together so quickly. Marine, I want to also thank you for writing her and getting everything together in like 2 or 3 weeks. So thank you so much for that. So today, I think we have a very interesting opportunity to discuss and compare systems. And we were talking earlier. We were talking earlier today about what we should discuss here. But basically, our mandate is to talk a little bit more about judicial review mechanisms and challenges in administrative decisions issued by public authorities. Fritz, I think, will be able to tell a little bit about what's going on right now in the U.S., the challenges, and how the Supreme Court has already ruled on one of the cases or a few cases. But I just wanted to initially ask Fritz, just for our benefit, to talk a little bit about the system, maybe talk about the judicial review administrative rulings, specifically with the Securities Exchange Commission, which I think there's a lot of interest here. Just by way of introduction, our system in Brazil, our CVM, which is our Securities Exchange Commission, was set up in 1976. The gentleman you see in your left, I won't mention, but I think he's the dean, the oldest director, and I had the very good fortune of being his colleague at the Council of Appeals of the Brazilian Financial System in 2015. We spent 3 years there, and this guy. I mean, he was, his history is incredible. He was with the Brazilian Central Bank for a long time. I think he retired at the Brazilian Central Bank. He was with the Securities Exchange Commission also. He was in the Council of Appeals of the Brazilian Financial System. And so it was a real treat to be able to interact with him there at the Council of Appeals of the Brazilian financial system, where I stayed from 2015 to 2018. But just to get the ball rolling, Fritz, in Brazil, so we have the Securities Exchange Commission. Before that, the Brazilian Central Bank was in charge of overseeing the Brazilian financial system, which included what the Securities and Exchange Commission does nowadays. In '76, Law 6385 was enacted to create the CVM, the Securities Exchange Commission of Brazil. And it's modeled in your Securities Exchange Commission, which I think is basically the model for all financial authorities, market authorities in the world. I think we do some things a little bit different. Here in Brazil, the Brazilian CVM, it does regulation. It basically oversees the market, and it rules on cases, administrative cases, which impose fines, which impose decisions that basically forbid administrators of companies, members of boards, to basically take these members of the company, and the rulings. Sometimes what we do is we forbid them for working companies for like a few years, or so we do that also, and we also rule on two types of administrative procedures: the PAIS, which punishes companies, and there are other administrative procedures in which we oversee rules of the market. We oversee the day-to-day work of companies, and we look into the interpretation of our rules with investment funds, with companies. But I understand that the Securities Exchange Commission is a little bit different, because in the part where you guys investigate, and when you impose fines, or when you rule on cases that have repercussion in the criminal law arena, it's basically done by a court of law, a federal court, and the DOJ. So it's an interaction, an administrative court with the DOJ, and which has arresting powers, subpoena powers. Mm-hmm. So it's straight into the judiciary, and not as in Brazil, where it's an administrative level that can then be challenged in the judiciary. Is that true, Fritz?
Yeah, so it's sort of. Yes, it's similar. So in the United States, just taking one step back, like the power. Oh. Okay. All right.
Closer.
Is that good?
Yeah.
Okay.
That's
so in the United States, like the power of administrative agencies over the last several decades have like ebbed and flowed depending upon events that have occurred. So just with regard to like the modern sort of securities fraud, the Securities Exchange Acts of the 1930s came in wake of the 1929 stock market crash and then the Great Depression. And then over time, the power of administrative agencies and the SEC has really, ebbed and flowed. So just to give a couple of examples of just, in my lifetime, basically dating from the beginning of it, in the 1980s, you have a huge amount of deregulation under Ronald Reagan, and the power of administrative agencies and their resources are pulled way back. And then over time, administrative agencies become far more powerful in the United States again, sometimes for reasons that aren't totally intuitive. So one of the big reasons of a great increase in the administrative state was throughout the presidency of Bill Clinton. He was of one political party, and the legislature was a different political party. So you have very limited options of getting your policies through. And one of those options can be to start really bolstering the administrative state, the administrative agencies, because the executive has control, not over all of them, but over a lot of them. And funny enough, actually, with one of the people who helped engineer this increase in power of the administrative state, is now sitting on the Supreme Court. I went to law school at Harvard, and she was the dean then, but Elena Kagan worked hand in glove and taught administrative law at Harvard. But now, and then turning to the SEC specifically, I'm sure everybody remembers the financial crisis of the late 2007, 2008, and the passage of Dodd-Frank. And one of the things that happened with the passage of the Dodd-Frank Act was that the SEC was able to bring a lot of very serious administrative actions in-house within the SEC. So they were able to bring claims for violations of the anti-fraud laws of the SEC, so like Rule 10b-5 cases within, so that it gets tried not in a court, but in front of something called an administrative law judge within the SEC. So that gave the SEC far more power. Understand the logic is, of course, understandable because of all of the incredible, over risk taking by large banks, among many other things that caused the financial crisis. Mm-hmm. But the issue that has run into since the passage of Dodd-Frank is that the Seventh Amendment of the Constitution of the United States guarantees everyone a trial by jury for suits at common law over a certain amount of money. Then it was $20, which of course, not too much today. So what does that mean for the SEC? Well, last year the Supreme Court ruled that for the SEC that means any action where you're seeking civil penalties, so penalties for violating the anti-fraud regulations, so securities fraud, things like that, they have to be brought in the first instance in federal court, because if you don't, it violates the Seventh Amendment of the Constitution. So the consequence of that is actually pretty significant, because within an agency you have streamlined procedures. There was an argument that the scales were tipped too far in favor of the SEC. They won the overwhelming majority of the cases that were brought internally as administrative actions. But now we'll see, it is just when you have to bring your enforcement action in the first instance in court, it's just going to take longer, because as you get to, in federal court in the United States, I don't know if anybody's had the opportunity to participate, but there are a very large number of procedural mechanisms that need to be observed, understandably so, that are not streamlined. So in that respect, yes. So that is a very new ruling. As a practical matter, there were lower court rulings over the past 10 years that sort of indicated this was probably the way the Supreme Court was going. So the SEC has been bringing most of their enforcement actions seeking civil penalties in federal court already. But what this now raises is, if you read the opinion, yes, it's about the SEC's power, but there's no reason why it shouldn't be extended to every agency in the United States. So if you're seeking anything that looks like civil penalties that would have entitled you to a trial by jury in 1791 when the Constitution was ratified, then you have to have the ability to defend yourself in front of a jury. So it has massively huge implications. And there's the other Supreme Court case also decided last year, was that the deference for decisions and actions by an agency when they're reviewed in court since 1984, so for 40 years, I guess at the time, the agency action was given very, very, very extreme deference. It was really, 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 really hard to overturn agency action. But then last year, now that deference is basically gone. It's the courts can review agency action through and their interpretation of agency action through any way that they want, including the agency's experience regulating whatever their industry is. But it really is given a lot more power to actually do like a real review of administrative action. So all that is to say, a very long way of saying that the administrative state in the United States is definitely ebbing right now. And in addition to that, the current administration has made it a priority to cut back on regulations, cut back on funding for administrative agencies. So this is certainly a period of ebbing. But with regard to review, the SEC still does have significant powers in the United States. It, of course, has regulatory powers, and then it has an enforcement wing. Post the Supreme Court judgment of last year, the enforcement wing, still undecided, but probably can still bring enforcement actions that would get relief that wouldn't be considered to be like relief in law. So things like cease and desist, stop what you're doing if there's some sort of like Ponzi scheme that's detected, or suspending a license, or barring you from the industry, or even actually disgorging profits. So it's just something that's been passed down from English common law in the United States, is that it is a claim that is a claim in law if you're seeking damages. Okay, this is going to be very oversimplification, but if you're seeking damages, so I sold you security based on false pretenses, and you suffer damages because you paid like however much money you paid for it. Okay, so that your claim against me for damages, that would sound in law. But if the agency is seeking just to disgorge just the profits, because presumably even for something fraudulent you have done something, then that disgorgement of profits sounds in equity. So that actually would not entitle you to a jury, theoretically. But that's still unknown. It's still like what the powers are. So yes, but for those, so for SEC action, the review is going to be, it will still be deferential. So for the SEC especially, there's a statute on it that if the decision is supported by substantial evidence, then it will be affirmed by the federal court. And substantial evidence is defined, it's not very enlightening, but it's more than just a little bit, a scintilla of evidence, but it's not so much that people couldn't disagree, right? Even if reasonable people could disagree on the evidence, if there's enough to support both sides, then they'll affirm the SEC's action.
No, excellent. I think we're going right into the subject matter, which is the judicial review. We've talked about CVM, what we do, and it's basically, as I mentioned, the regulation, supervision, investor protection, and market performance. We look at the security market, but going directly into the matter at hand here. I've spoken to a few of the justices in Brasilia, São Paulo, and Rio. There's a justice in Brasilia, federal justice João Carlos Maia Soares. He's a federal regional court of the first region in Brasilia, which has Brasilia has a lot of cases because all of the agencies are in Brasilia. So the federal court in Brasilia rules a lot of these cases. So for one thing, in my case, what I do is I rule on the administrative cases as a commissioner, and we try to be absolutely technical in the rulings. We have the advantage of being very specialized, and when I say we, I mean the superintendents and the technical staff. It's incredible how they are specialized. I can't say enough about the folks at CVM. Talk about the unsung heroes, right? But they really do a great job. They're very technical, so they give us a lot of support. So when we talk about specialization, and this goes to the discussion of the matter here, the fact that we are specialized for almost 50 years, we'll be 50 years old in 2 years, 3 years. We have the information, we have the cases. Everybody spent more than 10,000 hours in terms of becoming specialized, and we follow up on the companies, so we have the resources, right? So I was talking to Justice João Carlos Maia, and we have a lot of very learned scholars and specialized justices. Justice Cueva, Justice Belize, who just rendered an important decision on arbitration that I think we'll talk about this year still. Justice Salomon, who had a tremendous participation in interpreting our judicial recovery law, akin to Chapter 7, Chapter 11 you have in the U.S., 2005 from 2001 from 2005. Justice Noronha, Justice Buzzi, Justice Sebastião Rego Jr. So we have specialized justice that have a lot of experience. Justice Cuerva, he was a member of the Council of Appeals of the Brazilian Financial System. He was also a member of FTC. So, you know, for one thing, and I spoke to Justice João Carlos Maia this morning and this week, and what he has exposed in several of his talks is the outline on legal security. What we're talking about is the judicial review is based on several principles. And basically what the judicial review does is it assesses whether the administrative court has abided by the constitutional principles of ample defense. So what we're talking about, the legal security, which as a fundamental principle, and this legal security, what the courts look into is whether, you know, the ruling that's being rendered by the court, if it guarantees stability, predictability, certainty in the legal relationship. What the courts try to is ensure that legal standards are clear, accessible, and applicable consistently, allowing people to plan their actions with confidence, avoid unexpected surprises. So in short, and this is the doctrine of the justice, right? It is the guarantee that the law will be applied fairly and coherently, protecting the rights and duties of all citizens, right? So predictability, stability, trust, clarity, consistency. And there are several rulings of the Supreme Court of Brazil. And one of the issues is the control of discretionary administrative action. Usually the courts do not go into review of discretionary acts of the courts. And administrative discretion is opportunity and convenience, and we talk a lot about opportunity and convenience. Review of reasonableness and proportionality of the act. There's a ruling from Justice Toffoli, and I must say that Justice João Carlos' claim to fame is to have all of the jurisprudence in his head, right? So a lot of people talk to him, and when I talked to him last week in Brasilia, it's incredible. The man does have a lot of the rulings of the Supreme Court, the old, the new rulings. So, so the abusive power, abusive arbitrary act, illegitimate rulings, absence of violation of the principle of separation of powers. They respect the separation of powers. And when we talk about the control of the discretionary administrative act, what we do at CVM, we apply the business judgment rule. So my interpretation as a commissioner there, and that's my opinion, we do not oversee the financial and the economic aspects of the deal and of the acts, and that's what we do. But the discretion of the administrative court is withheld or political act. There's also this ruling from Justice Rosa Weber. So the review of link elements of the administrative act, we consider different. The courts consider different degrees of binding. The control of the judiciary branch without causing any interference in the administrative merit or violation of functional powers, separation of powers. So there is the control of the regulatory discretionary administrative act and the technical discretion of the regulatory administrative act. There are some very good rulings that I should mention. The regulatory agency model, sectoral regulation, normative function, the power to issue normative acts aimed at organizing and monitoring regulated activities, the power to subordinate to compliance with the perimeter established in the constitutional order and sectoral legislation. There's another ruling from Justice Rosa Weber. Legal nature of decisions, technical administrative decisions. There is the doctrine of judicial self-restraint And this, I think, is a very important doctrine, which is a deference in prudence. And according to the classification by Richard Posner, the structural self-restraint and production self-restraint. So the judicial control must be carried out by deferring to the constitutional powers of the other branches of government. Therefore, and I quote, in this model of action, one should not act as if one were seeking to replace the executive and or legislative branches with the judiciary branch in order to transform administrative discretion into judicial discretion, close. And this is from our friend, Justice Luis Fuchs, who I must say is a long friend of Flavio, because they were in the same study group of civil procedure.
Yeah, that's right.
Since the 70s, right?
Yes.
Yes, in Copacabana. So considering the principles legati and presumption of legislative acts performed by the public administrative, excessive judicial interference constitutes potential risk of violating public order, especially when discussing issues of eminently technical nature. So I think a very important distinction to make here is when it's a very technical subject, I think the courts, what they do, I don't want to sound oversimplifying it here, but there seems to be a lot of deference to the administrative courts that are very specialized. This right now is a tendency in Brazil, and I hear that in U.S. everything is changing. There's another ruling from Justice Laurita Vaz. I'm just going to quote this final ruling here, right? I think is very important from a very important Justice, Francisco Falcão. And I quote, therefore, the judicial body, strictly speaking, and except in cases of manifest illegality, is prevented from adopting a basis other than that given by the executive branch, particularly in technical and complex matters in which the courts do not have the expertise to conclude whether the criteria adopted by the administrative area is correct. This is a ruling from Justice Laurita Vaz. And an administrative act based on a technical basis is presumed to be legitimate, and it must be clearly demonstrated that the public administration made a mistake. So there is a lot of deference to the courts. But I just wanted to hear your feeling on how does this sound compared to your system and the current scenario right now, which for us, I think is very rich, and for you also, since you're going to have a lot of work, right? So
a lot of what you just read is very familiar, because that is for probably decades prior to the recent past, very similar to the United States. So that agencies were presumed to have the technical expertise, so that their actions would be given great deference, because who are judges and courts to step in and presume to decide between two parties, which is right or which is wrong in challenging an administrative action. But that it was named Chevron, the oil and gas company, from 1984. But that is most certainly not the prevailing feeling today. But I also think that today there is still deference to agency action, for sure. And in the United States, regulatory agencies govern. They have rules and regulations that govern just as much, if not more, than federal statutes do that are passed by the legislature, for sure. But the tendency to the ability to defer and the tendency to defer have greatly been reduced. I think there was a large groundswell in thought that certain specific agencies had been going too far, had been promulgating too many regulations, had been trying to basically regulate by bringing enforcement actions, so that they are, and I'm talking specifically in the financial sector, so they are bringing enforcement actions even though the underlying regulations spelling out what you can and can't do weren't really there. And I'm not trying to give an opinion, I'm just stating what are prevailing arguments. So, for example, the types of cases that were being brought against, like cryptocurrency exchanges and things like that, had they gone too far, whether crypto, like Bitcoin, other cryptocurrencies, whether they're a security or not. so like there was a much larger portion of the population was thinking these regulatory agencies are going too far, right? And there is a tendency, I spent a lot of time in the Department of Justice, and there is a tendency, I'm not saying this happened, but I have observed it to happen, that federal agencies, once they get to a certain level of size and power, start to do things to increase the power and prestige of that agency that might be more in the interests of the agency than the overall population. So, right, it was the famous old quote that the sole purpose of a bureaucracy is to perpetuate the bureaucracy. So, this is my own personal opinion, that the ebbs and flows are not necessarily bad. So now you have a huge ebb. So now you can see not just in deference to there's obviously judicially not as much deference to agency action, but like the amount of agency action is being pulled back. Anybody can read in the news like public closing of very large scale enforcement actions and actual and investigations of cryptocurrency exchanges and other things in the United States to try to pull back on the administrative state. So now it's and the other sort of new-ish development is, and you were mentioning how questions of administrative law typically happen in Brasilia because that's where all of the administrative agencies are. And traditionally that had been the same in Washington, or I'm sorry, in the United States, because they were all in Washington, D.C. So you have several different circuit courts of appeal, all of which cover multiple states with the exception of one, and that is the D.C. Circuit is only over D.C. And part of that reason is there were so many claims that were brought in D.C. because of the administrative agencies. But now challenges to administrative action are much more frequently being brought elsewhere, and they are being brought in places where the litigant believes that they may be able to find a decision maker who would be more inclined to decide in their favor, depending upon political persuasion. Either way. So that's been a change. So you have a lot of important decisions of administrative law coming from Texas and elsewhere.
How this foreign shopping is made.
So I always found forum shopping is like it always has like a negative, at least in the U.S. a really negative term.
Yes.
But I actually never felt that way. I mean, maybe it just reveals my own background. That I mean, if you have the discretion under the law to bring a case in one place that's going to be more favorable to you, like you really wouldn't be doing your job if you didn't do that. Now, from a higher perspective, do you want to change the law so that they have to be brought in one jurisdiction? That's more of a theoretical question, and that then feeds back into the ebbs and flows, because you have a certain portion of the population of the United States that believes that like large cities on the coast are out of touch with like the social and economic thoughts and needs of the rest of the country. So if you concentrated all administrative, any challenge to any administrative action just in one court, there would probably be pushback to that. Certainly now and probably forever. So you do get uniformity for sure, which is incredibly important, but probably at the expense of some like innovation, to say it differently.
And Justin, just one thing, if I may. For what I've known, it's the Chevron doctrine was based on a two-step rule. So first, there was an examination of the fact that the law to be interpreted should be or had to be ambiguous or not so clear, and then on step two, if it was clear, okay, the court should defer to the interpretation given by the administrative agency. However, if the if it was not true, if it was not so clear, the court could, in fact, the court could step in, but the general rule would be to defer.
That's right.
Right, and now this has been overruled now in last year, in June last year. So, what do you think? I would like to, if I may, about the checks and balances, because we have three powers there. Because we have the law that was made by Congress, and the interpretation that was to be given by the administrative agency,
yeah.
and then the review by the judiciary. So how do you see this balance right now? Now that from since last year, this understanding had been changed by the recent decision by the U.S. Supreme Court.
So I'm going to give you a very mealy-mouthed answer, and that is no one can know, because we're now in really, like previously, it happens all the time that you're in uncharted territories and people figure out what's going on and everything generally turns out to be okay. But it is a great question, because, and you're right, that's exactly the step. We in the United States get our law handed down from England, and you interpret statutes, similar types of canons of interpretation of statutes and contracts, which is what you say. Is it ambiguous? If it's not ambiguous, you just how it's written. If it is ambiguous, what interpretation is reasonable, right? So now a court does not have to give the interpretation to the agency. Well, undoubtedly, that means that there will be far more regulations struck down than previously. I mean, it couldn't possibly be any other way, which actually coincides right now with the goals of the administration, which is to cut back on regulations. But the reason why I say that you don't know is everybody thinks they know something until they don't. So basically the bread and butter fraud statute in the federal fraud statute in the United States of America is called wire fraud. So it's called wire fraud simply because the federal government cannot pass statutes, the legislature can't pass statutes unless they're authorized to do so by the Constitution. And the typical hook you get is any laws that affect interstate commerce, all right, fall within the powers for Congress to act on. So, fraud, typically like a state court action, but it becomes federal if an interstate wire is sent, it related to the fraud. So it could be anything. It could be a text message, a phone call, a fax, anything, a transaction, any banking transaction. Okay, so wire fraud, and for the last few years, the Supreme Court has kept cutting back on the use of the wire fraud statute. And it was always typically down like ideological lines of who was appointed by who. But then yesterday, there was an opinion handed down about basically like, was it going to gut the wire fraud statute? And everybody thought, sure, this is the perfect opportunity to do it, because it was weird facts where nobody really lost any money. Okay, and to some people's surprise, the Supreme Court decided 9-0 that no, this was a perfectly fine use of the wire fraud statute. So that's why I say that it's hard to tell. Undoubtedly, more like when courts have more discretion, it'll be exercised by some and not by others. But it's hard to tell just how far it's going to go without seeing it, because I just don't think there's some, but a huge number of federal judges in the U.S. who are like die hard and trying to, change the world by ruling that administrative agencies can't do anything. By and large, federal judges are very experienced jurists who have really they like to respect the traditional separation of powers, right? As we don't tell the executive what to do unless it's what they're doing violates. We interpret the laws, right? But we don't tell them how to do their job unless they're violating the laws. And the same thing, with the executive. and the legislative branch. So it's really undoubtedly there will be more regulations and administrative actions struck down, undoubtedly. But whether it's like a huge change to like wipe out all regulations or it ends up being not as significant, we'll see.
Let me ask you one thing. That's a very good point you raise. Let me mention. I was looking through the technical discretion of Regulatory Administrative Act, Discretionary Administrative Act, and I was looking at the North American model. Okay, so we were reviewing here the Chevron Doctrine, which is the Chevron USA Inc. Natural Resources Defense Council, 1984. And it imposed a duty of restraint on the judiciary when assessing decisions by the administrative bodies when taken within the margin granted by the legislator. More than the judicial deference, the technical capacity of the agency, the proceeding consolidated the so-called administrative state. Now we're in 2025. And now with it, the executive was recognized as having its own and broad space to define regulatory perimeters, not limited to the explicit permissions of the law. Later in Law per Bright Enterprises et al. Versus, which is now, right?
That's the most recent decision.
Here we are now.
Yep.
Law per Bright Enterprises et al. Versus Raimondo. June 28, 2004. This is a 6-3 decision. The Supreme Court ruled that in addition to denying that the judiciary owes deference to the technical interpretation that an executive agency gives to the law, or to its ability to fill the gaps left by the legislator, the courts, and I quote, may not differentially acquiesce to an agency's interpretation simply because of the law is ambiguous, I close quotes. In practice, this means restricting or limiting the technical discretion of agencies, while at the same time removing their integrative jurisdiction over the fringes left by the legislator. So, you know, that's a big change.
That is a big change. It is a big change, and it reaches so many different things. Just like so, in my own practice, when I was still at the Department of Justice when it first came down, one of the things that it reached here that was not immediately obvious to me is the deference you give even to like the sentencing guidelines. So when a criminal defendant comes up for sentencing, like what deference do you give to the interpretation of these sentencing guidelines and guidance on them? Because previously it was complete, right? And you never even need to think about it. And within days of this decision, we start getting sentencing memos challenging, you know, the types of a sentencing is it's set by a sentence in federal court for a criminal conviction. The sentence is imposed by the judge. And the judge looks at two things. They look at a set of guidelines and then a set of basically like things to think about to like, you know, even though this person, the guidelines say they should go to jail for 15 years, you know, they've done all these other good things or they have some sort of need, so we'll cut it down to 6. Very simplification. But the schedule is pretty definite, and within days, the way that the way that the schedule like should or shouldn't be calculated was being challenged. So these types of decisions do have really extraordinarily far-reaching effects.
No, for one thing, there are a lot of folks from different courts sending messages and watching this. So just, you know, Justice Fernando Chagas is watching, Justice Ricardo Alberto from Rio, folks from Brasilia. There are José Luis, I have to mention here, is in the first row, but he should have originally been here with us, but for some reason he decided to not talk today, but he's here. José Luis has a lot of experience, and he was always at the Court of Appeals by the Brazilian financial system. Eric Eoli, the president of CADE, Alexandre, the president of CADE, Rosman, Phil Midling, I have to mention, our friend from Wachtel Lipton is supposedly watching. The folks from CVM, Mauricio, Daniel, Kochman. So I just wanted to, Eric Eoli, Tito, CEO from Machado Meia. And so I just wanted to mention these names because they are actually sending messages here. But just going ahead here, a typical case challenged in federal court in Rio, and now specifically CVM, a typical case that we see is individuals or companies going to court, federal court in Rio, the third district, third region in Rio, to request usually preliminary rulings. In this case here, it's an appeal already, in which the preliminary injunction was granted, and it's appeal against a decision in a precautionary remedy, a request for a preliminary injunction in a procedure, but this is actually federal court in São Paulo, so I take that back. To suspend the effects of a decision of the Board of the Securities Exchange Commission that rejected a hearing of witnesses in the administrative sanctioning procedure. So it's in this case, I didn't obviously I've just, this is second-hand information, but what the individual did, he went to court, federal court, to suspend the decision from the Securities Exchange Commission. The second is the administrative sanctioning proceeding and the sentence imposed on the plaintiff in this procedure. The determination was that the defendant, the Securities Exchange Commission, should refrain from notifying publicly held companies to replace the plaintiff. So this was a ban from market and on an individual. CVM was forbid from was supposed to refrain from notifying publicly held companies to replace the plaintiff in the positions currently held by him, while the suspension of the effects of the decision persists. This is the typical appeal to challenge usually procedural aspects of the ruling. What usually CVM, and this is public, so I'm not spilling any beans here, but what usually CVM alleges is the prevention from preclusion. And in a few moments from now, Elaine will be here. She's teaching a class, and she is our friend from the Council of the Appeals of Brazilian Financial System. Very, very seasoned prosecutor, very brave. She took on very important cases, and she's teaching a class right now. But she will be here in a while. She has a lot of experience with these cases. She's very gung-ho. You'll see when she gets here. But in this case, there was a preliminary matter, preclusion. Usually CVM alleges preclusion does not apply, which preclusion being the loss of the possibility of performing a procedural act, either due to the expiration of the legal term or due to its incomplete performance or incompatible with what should have been performed. So in this case, there was a review of the original ruling. This case was filed, there was another case filed in federal court in Rio. And the legality of the decision of the CVM board, there was no violation of this is a ruling on this case, and this is already appeal in federal court. The legality of the decision of the CVM board, there was no violation of the principles of adversary legal proceeding and broad defense, which is a constitutional principle. The witnesses were heard during the investigation phase under protection of Article 14, Instruction 607. A rule accepted and repealed the CVM Resolution 45, 2021. The statements are in the records and are subject to collegial assessment, including defense perspective. The request for a new hearing, was denied on the grounds of lack of evidentiary utility after a number of years on the facts and given the repetitive nature of the defense claim, with merely delaying potential. The truth about the facts, the possession, there's a few jurisprudence here. So this is the typical challenge that our prosecutors defend. I liked it when you mentioned, just passing it over to you, when you say it's not your opinion. And we have a very seasoned attorney called Sergio Bermudez, and he used to say that only clients have theses. Attorneys don't have theses.
That's right.
They have their.
That's right.
So, and you've mentioned before that you like to be Switzerland, right?
That's right. Well,
since that
I'm Switzerland until I have a client who needs to be advocated on behalf of. Then I'm probably more like a more bellicose country. But yeah. When giving speeches.
Just to complete, when you mentioned, I think it's a very important point, the bureaucracy, right? And we as the commissioners, we need to have that fine-tuning, and it comes from experience, right?
Yep.
And working with people like Flavio, which I did for 3 years. So, but the experience, the fine-tuning, and understanding, I think, which is very important. And this is a case where it's being reviewed, which is a case of insider trading, right? Which is the type of case that is, you have to look at the evidence, but you have to understand the financial perspective of the case and understand the incentives for people to do things, right? Why would someone do this or do that? And the economics behind it. I think the toughest thing is to understand the incentives and the economics of the deal. My experience, and you spoke about, which is an interesting point about bureaucracy, commissioners and people that serve, they need to understand the equilibrium, right, of the market and how the market works. And it's not, the equilibrium, I think, is something that takes time. And but for one thing, I think that in these cases, we need to interact. And in my case, I have Claudio, Ricardo, who are two they're people that have been at CVM for like 30 years. And what they have is the eye to understanding the case. They might have, their type of understanding, but they can review cases in a way because they've been inspectors in the past. So they can really review tendencies, facts. So I think a trick is how to interact with the folks at CVM. They have a lot of knowledge. They're very experienced. If you work with them and you try to do it like in 10 hands working together, it works the best. The teamwork, working with the folks. But I want to, after having said all that, if you have any comments on these points and how this works in the U.S.
So I completely agree with civil. So my experience in the government was as a federal criminal prosecutor, and my cases were virtually all. They were all financial fraud, and then a split between securities fraud and healthcare fraud, like basically fraud in the government.
Lisa, right? We have to mention Lisa.
Lisa's a very good friend of mine.
She was with the DOJ.
She was my old boss.
And now she's in private practice also.
Yeah, so Lisa, she's someone who was in the Department of Justice for a long time in Miami when I was down there in Miami, and ultimately she came up to be a politically appointed person who oversaw
equivalent to Arileni.
Oversaw
very tough, very gung-ho, very focused.
Yeah, exactly. Not the entire criminal division, but a big portion of it. So in my cases, what I there was almost always a parallel civil investigation happening. So I would have my criminal case, and then there would be a civil case, and for reasons that are obvious. There was tension between the two because both sides wanted to show their worth, and they wanted to be the ones to just to be honest, to get credit for holding the person accountable or the company accountable. But I always really I tried to work against it. So I would have these seminars where bring all the civil people and all the criminal people together to talk, because it's exactly what Otto just said, is that the civil agencies that have regulatory and enforcement power, they have a far deeper subject matter knowledge, okay? Far deeper. So they have a lot of great perspective on the market they can give to you. And the flip side of that is on the criminal side, which is, I don't know if this is good or bad, but we had extraordinary powers of investigation that were denied to the civil people. So it was trying to find the right balance of working together to get the subject matter knowledge to then use those tools effectively, but not in aid of the civil folks, because that is not allowed. So basically, the long way of saying is that the subject matter knowledge is critical to effective regulation and enforcement. But I think that the sort of what I guess probably maybe I'm just going to repackage what I said again before is. The more powerful you get and the longer you do anything, the more is the tendency to have mandate creep. You want to do more and more and more to show that you can basically do anything. And the problem with doing that is the biggest problem from my perspective. So when I was in the criminal division, there were lots of cases we could have charged that we didn't because I didn't think that we had like the subject matter expertise to do it or whatever. But my fear was not so much that we would charge and lose. It was that we would start creeping our mandate out so far that somebody would come and be like, what are they doing here? And then that would probably be somebody who is aggrieved by what we were doing. And then the result would be for the agency or for my unit is it wouldn't just be that like, okay, you guys need to back off these cases, but it would be a full review of like, what is your justification for existence? So I think some of the times, so I was always like very careful to be like, our job when the healthcare fraud unit is to prosecute healthcare fraud. That's it. We can do some stuff on the sides, but that's it. We stick to it. And then nobody comes and accuses you of overreach. And, there's like a lot of arguments of regulatory overreach in the U.S. right now. I'm saying I agree or disagree, but I can understand that there were attempts to move farther than maybe, the original thought was when creating either the agency, the task force, or whatever.
It's a pendulum.
Exactly. Right. Then the pendulum swings back, and presumably it will swing back again. It always has in the past, so no reason past is prologue, it will happen again. But yeah, I mean, it's just it's using the subject matter that is then tempered by like the procedural security, right? So you have courts don't have the subject matter of really esoteric things, but they have the procedural safety of making sure you have certain basic rights that are respected when you are the one who is accused. That this agency with great subject matter knowledge can't then just kind of like roll over you,
Yes, and just one thing, the market responds to that. So the businesses, companies in general, so you mentioned healthcare and financial businesses. So they make decisions based on how the courts respond,
right,
how the agencies act. So, and this interaction between them, it's crucial for certainty in a higher level.
Exactly, predictability. The most
the predictability.
Thing.
Yes, the legal certainty, regulatory certainty.
Right. I'm hoping we get back to some predictability and certainty soon, but there's a change afoot at this very moment.
John, I just wanted to mention we now have Eleni here with us. Eleni is the equivalent of Lisa, right?
Okay, great.
Nice to meet you.
And the good news, she's just been remanded for 3 extra years at the Council of the Appeals of the Brazilian Financial System, so where Flavia and I stayed for a while. And she a very, very seasoned prosecutor, very tough. And she spends the whole day doing hard work at the prosecutor's office, but she teaches classes in several universities. She studies the new technologies, crypto, token. Elaine, do you wanna say something? I mean, do you wanna talk a little bit about the subject? What do you want to do? You're the boss, basically. So
Not as prosecutor, but as judge.
Right. Yeah. But for one thing,
Thank you.
Thank you.
Here, and sorry I'm late because I was at CVM before doing some kind of audience there.
Okay.
But it's a very nice to have you here. It's a pleasure. It's an honor for us.
The honor is all mine, please. And if you're the equivalent of Lisa, then if you have somebody who handles like some portion of your cases, then I'm the equivalent of that person.
But I wanted to quickly mention. So people are sending messages here. Your folks from Queen Emmanuel are watching, JV and the other folks. For one thing, John may very well welcome everyone to go to November in New York, where we will have some.
Okay.
Sim. Tá bom. Alô. Okay, so I just wanted to mention some of the people that are following up on these discussions. For one thing, we have Justice Luis Fernando from Rio, Justice Agostinho. And I just wanted to quickly mention that whoever goes to Lisbon on the event that will be held in Lisbon on the 30th of June, 1st of July, we will have an event in Lisbon and it's basically an interaction between the regulator, the Portuguese regulator. I go as a professor because I'm on vacation, but I go as a professor, not as a member of the Brazilian Securities Exchange Commission. It's the Portuguese regulator, the courts of law, University of Harvard, University of Lisbon, USP, and UERJ. José Luis has been to these events in New York. We will have several events, and if we are invited by John, we will hold several events in Queen Emmanuel, Watchdale, White and Case, Hogan Hardson, and I think Clifford Chance this time. But so I just wanted to mention, Zé Luis was there last year, and we sat with Justice Strine, which was an incredible experience, and Phil and the rest of the folks there. So I just wanted to mention that will be November 19, 20, and 21 in New York, which I'll also be in vacation as a professor, not as a commissioner. But I just wanted to pass that on to Flavio and see, Flavio, where do we go from here now?
You mean from the next event?
No, what do we do now? Do we have time?
Yes, we do. We do have some, about 20 minutes.
Okay, so in terms of, John, that we discussed, I mean, I basically presented a typical case that we have in Rio, the challenges. But I understand after we spoke about Chevron, after we spoke about the latest case, right? And what are the future trends? What do you think will happen next? Do you think there's anything to learn from other countries that went through through this phase of the Supreme Court, in a way, authorizing local federal courts to review? Because I think it was unheard of judicial review of the rulings from the Court of Delaware, and it's more recent that the federal courts are reviewing specialized rulings from specialized administrative courts.
Yeah, I mean, the Delaware, you mean like the Delaware Court of Chancery?
What I gathered from the past is that very seldomly the Supreme Court of the U.S. was reviewing cases from the Delaware.
Oh, I see.
And I think now there is also this, but just as a follow-up question, what's happening with the venue shopping that we discussed before, and this new situation where companies are going to Texas and going to Nevada. And which I knew Nevada as a place for gambling, right? But it seems that that's a good place to set up shop now.
So the trend. What can other countries learn? I think it's just that everything ebbs and flows, and even with the ebbing and flowing, right, is that it affects cases in the margins, mostly in the margins, right? Because the overwhelming majority of actions that are regulated by administrative agencies or like criminal laws, like they're kind of unaffected because it's so clear of whether something like is within the mandate of the agency or not, or something is a crime or not, and that's good. That's how you want it to be. So I don't personally think that it's going to be like a sea change where is a big change where nobody gets any predictability and the whole world spins off its axis. I do think that there are special interest groups that will really try to think more so than companies, special interest groups that will try to pursue their own agenda, but I think that the biggest change, honestly, for administrative agencies more than just far more than judicial review of what they're doing is basically their marching orders. Is how will they be used by the executive, because that's going to be much more powerful. We're just not doing that anymore, or we're doing this, and the review right now we're not doing that, which is not necessarily a bad thing. That the review is it's sort of like the difference between changing policies and prosecuting people for criminal violations. Like, if a change in policy changes so much more than even the biggest criminal prosecution, which is how it should be, right? You want to focus on trying to keep the train on the tracks, not what you do after it's already crashed. So I think that the biggest changes will be just in the changes of how they are used and carry out their mandates, rather than overall how their decisions are challenged. And I think that's especially true when you have a time when the administrative agencies are getting pared down literally by headcount and by focuses of action. It is going to be far more. We're lawyers, so we tend to like really focus on things we know about, right? And we know how to deal with disputes, and I love it myself. But like policy action typically has so much larger of an effect, and things that are in the heartland, like taking this to like criminal law. There's been a lot of press that there has not, I would guess most people in this room have heard about the suspension of the enforcement of the Foreign Corrupt Practices Act. Now, that is a significant policy change for sure. Very, very, very significant. I don't think it's going to be repealed or suspended forever, but, and I don't mean to take away anything from anybody who's worked on these cases, but the FCPA is a very, very important statute, but the overwhelming majority of criminal prosecutions in the United States are typical criminal prosecutions. So I think that like things where people have been injured, right? There's violent crime, there's drug crime, there is financial crime, and what's going to happen, I think, is just from a policy standpoint, is that there will be a retrenchment back to like what standard crimes are. Like, only use the wire fraud statute for when somebody lies to steal money, not when somebody is like diverts a government employee from doing what they're supposed to be doing and depriving somebody of their honest services, which can't even fully understand. So I personally think that the bigger change than judicial review is going to be policy changes. That being said, there is a large opportunity to a much larger opportunity than there has been in decades to challenge agency action by those parties who believe they're aggrieved, because a very small agency action can have catastrophic effects on a company or an industry, and there's a much larger avenue to challenge whether or not that was done correctly.
Oh, that's excellent. I'm actually getting messages from Professor Carlos Portugal, professor from USP and Harvard, who is heavily involved in these events, has sent message. And I mentioned Phil Midley, a very, 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 very seasoned attorney from New York that has gone out of his way to welcome us at Washington Lipton. And very, very kind heart, has sent messages. And I must mention that we have the folks from the associations, Abrasca, Pablo from Abrasca, Thiago Duval from Abrasca, David from Encore, and other, Carlos Arnaldo from Encore, also a lot of the associations that do this type of work of following up the tendencies in the courts. So, Flavio, how are we now in terms of time?
We have 15 minutes.
15 minutes?
Can I ask the question?
Can I open up to questions?
Sure.
Should we do that?
Yes, I'm going to give you this.
Well, first of all, thank you very much, John. It's a pleasure to have you here in IASP, and thank you for sharing your knowledge and experience also with us. So my question, if I may, it's not exactly in regard with judicial review. It's more from a criminal perspective, which is my field. My question is, well, here in Brazil, as Otto knows for sure, and Eleni also, if we have wrongdoing in securities market, as for example, insider trading, we will have proceedings in CVM, well, our SEC, and at the same time, we will have proceedings in criminal field, or at the same time or after the proceedings in CVM. And what happens, I think, in the majority of the cases here is that our criminal authorities will repeat what happened in CVM, the decision. Of course, we have a specialized agency, and they consider, sorry about that, they consider that, of course, they knew what they decided, so the decision is very specialized, but they won't consider all the criminal elements that are involved and the differences between the wrongdoing in the administrative field and the criminal field. And it's like, for example, I don't know, I can mention, it's almost like a copy and paste decision, which is very bad for defense lawyers. So we have here an independence between the fields, but in practice we don't have it because it has a dependency. So I want to know, how does it happen in the United States? So if there is this independence of fields, or how the decisions can have this interlocution. So if there is an interaction between these fields. Sure.
John, can I say something now? So,
Sure.
Could you tell us about subpoena? Because Securities and Exchange Commission, they don't prosecute anyone. They have the subpoena power. They ask, please, can you tell us something about what you're doing? If person said, no, I didn't do nothing. So they call the judge, DOJ sometimes when they have criminal questions, and say, please, give him the subpoena. And the court goes on. Can you see, it's very different than here in Brazil. Here in Brazil, we have always ações ordinárias anulatórias de inquérito administrativo. We have also our CVM, our Securities and Exchange Commission, prosecuted as well, because they try to get away with it sometimes, going to the courts to say, oh, I didn't do nothing. And there in United States, it doesn't happen, because you are always going with the judge by your side. If Brazil, if we had subpoena power, our problems would be more easily to face.
Yeah, but I'm not talking about the investigation itself. I mean, it's more like when CVM analyzes the case or the facts, this will be the decision that the criminal authorities will consider.
But in the United States, it's the same. It's worse, in my point of view. Because worse for the lawyers. Worse for not for the prosecutors. For the prosecutors, better. You see, because they have the subpoena power.
Yeah, but I'm not talking about the means of investigation. I'm talking about the decision itself, considering the wrongdoing, if it happened or not, if it's a wrongdoing or not. So the criminal authorities won't consider or do another analysis. Of course, they can decide based on what CVM understood in the first place, but it's a totally different wrongdoing, because we have different elements in the criminal offense, you know. But I think, Flavia, please. Sorry.
Yeah, it's okay. Sorry, because I want to jump in and just to say some other things here. And as a criminal lawyer, I think that we always have this type of situation. And I totally agree with you, Maíra. And I think that it's important to hear from you, Fritz, if they can, like a CVM here, as we have here, exchange evidence that they get from, for example, the administrative proceedings to a criminal judge. So is the same in the U.S. As Maíra mentioned here, what we have in Brazil is that the criminal prosecutor is just waiting for the end of the administrative proceedings, and I think that it's also because our statute of limitation and other things. But what we see here is that the job was done. So they took all the evidence through the administrative proceedings and go further. Like they just press charges and they don't go to investigate further. So I would love to hear from you how is the things in the U.S.
Sure. Before I answer, two things. One, in case I haven't said it before, I'm very honored to have been invited. Thank you, Autumn. Thank you for being here. Okay, number one. Number two, I want to preface this with I had a 2-hour discussion with Flavia about this last night, so this is like top of mind. So in the United States, it's kind of the opposite. Not always, but typically the opposite. Typically, if the government, so the SEC or the Department of Justice, learns of potential wrongdoing and it looks like the wrongdoing could be serious enough to warrant criminal interests, then typically the criminal division takes over from the jump. So from the very beginning of the investigation. So there are many reasons for this, but one reason is that there are rules about grand jury secrecy in the United States. So what you do is there is always sitting in every district a grand jury. It's a group of 26 people who have to sit together for months on end. And they have a couple of different roles. One role is to gather evidence to see whether or not there is probable cause that a crime has been committed, and if there has, then to return an indictment. And there is great secrecy to what they do, so that they can do it without any outside interference. So even though prosecutors are giving subpoenas, grand jury subpoenas, and they control the whole show in the investigation, it's technically going back. It's at the will of the grand jury, and prosecutors can also then take witnesses, and put them in front of the grand jury to give testimony, and that's under oath. And people tend to be more truthful in that situation because they're afraid of being prosecuted for obstruction of justice. And when you go into the I'm going to start describing one of many extraordinarily powerful tools of investigation that criminal prosecutors have compared to the civil counterparts. And one of them is this, using the grand jury to investigate. So grand jury subpoenas typically are not secret. Like if they were to subpoena, somebody for records from their company, it would not, the recipient can tell people that they received a grand jury subpoena. But most in fraud cases, grand jury subpoenas are going to financial institutions to try to figure out where the money went, and they are by law prohibited from disclosing them. So that's like grand jury secrecy 1. 2 is nobody can tell. The only people who can say anything about what happened in the grand jury is the actual person. If they give testimony, they can go and tell what they said, right, and what they were asked. But when they go into the grand jury, they're not allowed to bring a lawyer. So they can have a lawyer standing outside, and they can go consult with the lawyer after every question if they want to, but by human nature, nobody does that. And they're answering under oath just there. Now, they can have certain protections, right? They're read their rights. They can exercise their Fifth Amendment right not to testify. There's no consequences. And typically, a prosecutor who wants to continue being a prosecutor isn't trying to trick somebody by going into the grand jury to trap them into being prosecuted. But in addition to that, in the United States, we have the ability to, once we have probable cause that gather enough evidence to show probable cause that a crime occurred, we can get search warrants. And then we go and seize cell phones, email accounts, search people's houses, whatever. But the most effective criminal prosecution in the U.S., you try to do as much as humanly possible before the person you're prosecuting knows that anything is happening. So basically, the civil folks their primary power of investigation is going to be subpoenaing documents, which of course is going to alert anybody if the SEC subpoenas you that they're investigating you, is that they basically step aside while the criminal investigation happens. Now, they can come and attend interviews. They can't go to the grand jury, cannot go to the grand jury. They can't be told about what's said in the grand jury, but they can come on voluntary interviews. Like if someone's like, sure, I'll just come talk to some agents and prosecutors. But so then the investigation proceeds. And one thing that you as a prosecutor, you're absolutely prohibited from doing is using your regulatory counterparts to gather information for you in aid of the criminal investigation, because you can ask them for the documents they already have. You can be like, just give me everything in your file. Fine. But you can't be like, I want you to go interview Flavia and see what she says to you, because, I mean, I'm going to put my own thoughts on this into somebody else's mind, which is, if somebody with civil authority is asking me a question, I'm going to be much more prone to not telling the truth than if somebody with criminal prosecutorial discretion is asking me that question. I'm probably going to either say nothing, most likely, or I'm going to tell the truth. So because of those huge powers, the criminal division almost always goes first. And then because there's a different level of proof that you need to show, so for a criminal conviction, it's proof beyond a reasonable doubt, which is like, you're like, what, 95%, 98% there. And civil is 51%, which is more likely than not. That if somebody is convicted of a criminal charge, they're really not going to have a defense to the civil case. They just, like, it would be impossible, right? I mean, almost impossible. So if you plead guilty to a criminal charge, you have to admit to certain facts that would make your defense to a civil case impossible. If you get convicted by a jury, the facts found by the evidence, it seems overwhelmingly unlikely that you would not also lose the civil case. There is very, very rarely there is a situation. Typically, it comes from the criminal division not having enough resources, or just a mistake that they didn't really review the evidence well enough, so they just are like, you know what, so civil division, whatever, you guys have at it, we're not interested. And then they go and they do their investigation, and then they win, right? They bring this person to trial, and they're hit with, sometimes substantial financial penalties. And then a prosecutor's like, sees the press release after the win, and the line prosecutor's boss emails them, and they're like, Jim, where were you on this 4 years ago? And every once in a while, then a prosecution will start up after that. But if it does, at the criminal prosecution, you cannot say anything to the jury about there being a prior civil case. It would be like automatic mistrial, because the jury is there. Every criminal case, you have a right to a jury trial. Every felony criminal case, you have a right to a jury trial. And the idea is they cannot be affected by the decisions of another decision maker, that they have to decide only on the evidence that's presented to them. So that's a really long way of saying is there actually is a true separation, but it goes in parallel. So there's some overlap, but a lot of it's kind of a black hole in the U.S. system. So the criminal division can't ask like the SEC component to do things for them, but they can ask for all their documents they've collected to date. But the civil division can't do this. I mean, they can ask the criminal division for the documents they've collected, but most likely answer is going to be no, not until the investigation is concluded. So really, like for the most serious cases, criminal takes primacy, and there's always some tension. And tension is within the government, not having to do with the defendant. Actually, one thing that I think is significantly different from, and we talked about this in New York, Flavio, with Roger, and we talked about this in New York with Rogerio, is there are far more powerful powers for defendants in civil cases in the United States to obtain discovery than there is in criminal cases, which is weird because it's much more serious stakes. It's putting you in a cage. So when there are parallel, like a criminal division prosecution and SEC enforcement action, sometimes it does happen. Like there's an indictment and a civil and like an SEC complaint that comes out on the same day. it actually offers the defendant like a huge opportunity. So defendants a lot of times want that civil case to go forward because they can use their discovery powers in that civil case to learn a lot more about what the likely case is against them by the government than they can ever do in the criminal case. So then there's a fight, right? So the SEC will want to stay it, and then the defendant, just keep it in abeyance, and the defendant will want it to move forward because then they can start deposing everybody and people, right? So a lot of times, understandably so, someone isn't being investigated for a serious crime and the people they thought were their best friends don't want to be charged, so they don't want to help, right? They don't want to go talk to the police for them. They don't want to talk to the lawyers for them or anything like that because they just want to stay out of it. But in a civil case, right, you can give them a deposition subpoena, right? And they have to sit for the deposition, especially if they don't have any legitimate Fifth Amendment rights. And then you know what they're going to, you have an idea, a very good idea of what they're going to say at trial. So it's almost the exact opposite. Like the civil case can be used as a tool by the defendant more so than the prosecution. So as a prosecutor, I had several civil cases that I never wanted them to go forward at the same time. So if there's a parallel civil case, I always moved to stay it, including one in the Delaware Court of Chancery that I ended up getting stayed. But yes, it's the exact opposite, really, completely. And there's no, you could very well lose SEC or civil action. I'm sorry. Yes, you could lose a civil action, but then be acquitted in a follow-on criminal trial.
Yes. Just to mention the OJ case, where we have nothing to do with regulatory agencies, but it is interesting from the point of view of the criminal and civil and this overlap, because he was acquitted at the criminal level, and then subsequently he was convicted. He was held liable for
that does happen a lot in the US.
Yes,
yeah. Mm-hmm.
And then he was held liable. So he.
Yeah,
it was a contradictory
that
decisions.
That happens frequently because of the different burdens of proof.
Yes, the standard of proof. So the preponderance of the evidence in the civil and the
beyond a reasonable
doubt in the criminal case.
I need subpoena power in Brazil, John.
I don't know how.
It's a dream. I have a dream.
I don't know how you could exist
power.
without it. Because we have so for my folks, I put together a checklist of things you do on the first day, and if you can't do it on the first day, then within the first week. And the number one thing is to get your subpoenas out to all the banks, to go subpoena the clearing houses to understand where other accounts are. It's just immediately the very first thing you do is open up the grand jury and start firing out subpoenas. So by the time a defendant comes to trial, you've probably served anywhere between 30 and several hundred subpoenas.
Yes.
Mm-hmm.
Great.
Yeah.
Let me just tell Pacheco is with us. Please, Alexandre
Bom dia, Pacheco.
President. Please.
Bom dia, Presidente.
As you were not here in the beginning of the section, there in the U.S., the Securities and Exchange Commission is under problem to get to impose penalties.
Civil penalties, yeah.
Yes, yes. Mm-hmm. So I think you are better here in Brazil than in the U.S.
No.
A lot of power already.
No, it's not enough.
It's not enough.
So President Alex is here. Thank you so much, Alex. Do you want to come over here? And Flavio, do you want to wrap it up, you guys?
I think we may finish now.
Okay. Yeah.
Flavio,
If there is
one more question.
One more question.
No.
Yeah. So I just want to say thanks to Marina, to Flavio, to Alex, to Eleni, and to John for, I think it was very, very good program today. A lot of meat, right? A lot of good discussion. So thank you so much for the association, YASP, and the board of YASP for all this hard work to put everything together. And Alex that came in so quickly and got things rolling. So thank you so much. Thank you so much.
Thank you.
Thank you very much.